So just to give you some context, a lot of times you may think you're crazy and alone, but in fact, it's a very conservative estimate that looking only at ODSP, not looking at LTD, short-term disability, workman's comp, CPP disability, none of that. If you're looking only at ODSP, conservatively, 1 family in 10 is directly concerned about this child or adult child with special needs. Could you just double check something for me?
Yeah.
I'm looking here. Does it look proper on the screen there? Am I looking at the screen?
Yes.
Is it okay?
Yeah.
Okay. This is just the second one we've done with this gear, so we're still getting things adjusted.
Yeah, that's good.
So you can see that conservatively, 1 family in 10 is either the parent or the sibling of a person with special needs. And the reason we know this is that the population of Ontario is 13.7. Now, that's a 2015 number, but I think we should go with that. And StatsCan says that if you take the population and you divide by 3, that'll tell you the number of households, because of course that's the real number. So if you divide 13.7 by 3, you get 4,566,000 households. Now, this chart on the right, on the bottom where the box that says all, don't add or don't double add renters private, renters subsidized. That's just the breakdown of renters, the 279. But the total number there comes to 362,000. And that's up from a couple of years ago when it was slightly over 300,000. So it's up substantially. It's up about 20%, which is very interesting, actually. Now, if you figure that there's 362,000 people on ODSP, and that they each have, this is age 18 to 65. This doesn't take into account the kids under 18 that have disabilities, or that are 65 and older, who now are receiving old age security and guaranteed income supplements. That's another third of this middle number. So another 100 and some odd 20,000. But if we don't include them, so you can see I'm being doubly conservative, then if you take 362,000 people on ODSP, and if you calculate that they have a parent household, that's 362,000 parent households of 4,566,000. So it's not quite 10% there. But then if you presume that there's 1 sibling household, and that sibling, for example, would be the trustee of the Henson Trust, that's 720,000 households, a parent household and a sibling household. And you can see that obviously, for it to be 1 in 10, the households would have to be 7 million and some odd thousand households. But it's not, it's 4,566,000. So we're being quite conservative here by saying that 1 family in 10 is the parent or the sibling of a person with special needs. Now, it's very interesting because that's a large number. And what I've always wondered, to be slightly facetious, is there are all sorts of communities in each of our cities. Like in Ottawa, there's a Jewish community and an Italian community and a Muslim community and all of these. And in Ottawa, for example, there's a Corso Italia, right? There's a street named for Italians. Well, why isn't there an Autism Way or a Down Syndrome Drive in Ottawa? Because what we know is that, and this will be particularly of interest to the financial advisors that have taken part in this session, in any group that you speak to, and in your existing clientele, 1 in 10 is either the parent of or the brother or sister of a child with special needs. Did you know that? Do you know which 1 in 10 is the parent of or the brother of? Because with the know your client rule that financial advisors are obliged to know their clients, to understand their circumstances, this is big, right? This is a core concern for these families. What will happen to my child when I'm gone? Right? This is not a small thing. So it's a big issue, and here's the breakdown, and I think these numbers are fascinating. One thing I want to point out is you see the number under all says borders, 46,000.
Yeah, 46,871.
So that's 46,000 of 362,000. So what's that? About 12%, 12, 13%. These are the people who are living at home with family. Now, typically, of course, most of those will be young adults. They've turned 18, they've started to receive ODSP, and they just continue to live with their parents, obviously. Of that group, we'll get into this on another slide, but what this means is that that's the number who almost all are receiving the room and board amount of $881 instead of the shelter plus supplementary of $1151, which is about $250. So on one of the slides that we get to, we'll discuss getting benefits increased, and that's the number. It's approximately 12%. Okay, what's the next slide? Okay, next slide. So there will be people who have young children who don't know that when their child turns 18, their child will qualify for financial and medical and dental and other supported living benefits under the Ontario Disability Support Program. And if you happen to be a single parent and you happen to have a low income, let's say $30,000, you could also qualify for assistance for children with severe disabilities. Now, it's not really based on severity. It's just based on disability and a low household income. So if you happen to be a single parent with a modest household income and a child or children, one of the children having a disability, you could qualify for ACSD, and this could provide you with up to $450 a month, plus other benefits, subject to household income. And it's something that most people don't know about, and we regularly assist people to access. Because if you're a single mom, this could be a big thing. Any questions about
Somebody had a question about the last slide, asking why the 13.7 was divided by 3.
That's just what StatsCan says. StatsCan says that if you divide the number of people by 3, that'll tell you how many households.
That makes sense.
Which makes sense to me, mom, dad, kid.
Yeah, okay.
Right. Any other questions so far?
There was a couple ODSP questions. One of them was, can an OMER survivor pension be placed into a Henson trust upon death of a parent to protect ODSP benefits?
Yeah, very common question. No. The pension is the child's pension. And with OMERS, the pension might well be a modest pension. Could well be $500 a month rather than more than that. And so, of course, it simply offsets ODSP. If it's a larger amount, such that it's greater than ODSP, well, great. But no, it just offsets ODSP. And it can't be put into a trust. It's a direct personal pension. And we'll get into these pensions on another slide.
Okay. One more. If you, as an ODSP recipient, as part of your asset limit, own coins of a cryptocurrency or shares in a stock, if the value of the coins goes up so as to take you beyond the asset limit, are you expected to disperse the excess amount right away and pay back ODSP? What if you don't?
Yes, technically speaking. You're supposed to stay below the $40,000 asset test. Yes, that's true. That's just that simple. Now, of course, with cryptocurrencies and other things, it could be awkward, determining the true value on any given day and then staying within the guidelines. That's perfectly understandable. Just stay on this slide for a second.
Sure.
So this is an update seminar, and a large purpose of this is continuing education for my client families. What we did initially for this seminar was I sent the invitation out to the 6,600 people that are on my newsletter list, which is composed of my client families, their children, financial advisors, support organizations, that sort of thing. So the benefits have increased. The 6,000 over 12-month gift rule has changed to 10,000. So it's 10 over 12. And the asset test has increased from 5 to 40.
Okay.
But otherwise, it's just that simple. 10 over 12 and 40,000.
Greg Bell is asking, his wife is a teacher, and he was told that when him and his wife die, his child will get the income, and he's asking, will he not then be entitled to ODSP?
Hi, Greg. How are you doing? No, it's that simple. For example, I have a client mom who's a teacher. She's in her 80s. She has a pension. It's about 60,000. She has a son who's severely autistic. He's in his mid-50s. He's at Carrie's place. And when she dies, he'll get, if he's dependent, this is the issue. You have to make sure that the child is dependent when the parent dies. But he'll get a $30,000 pension. Now, this, of course, will disqualify ODSP. And because he's not competent, we've made his sister his legal guardian, because otherwise there's no one to apply for the pension. He can't apply. He's not competent. So the sister, who is his legal guardian, will apply for the pension, and she will also receive it on his behalf and administer it. And what we'll probably wind up doing is Carrie's place receives $1,000 a month. Well, it receives his ODSP, so it keeps about $1,000 a month, more than that actually, and it sets aside about $150 for comfort money for him for bowling and travel and that kind of thing. So what we'll probably wind up doing is replacing what ODSP was paying. But if he gets 30,000 after tax, it's about 27,000. And if we give Carrie's place, let's say 12,000, that leaves 15. And he doesn't really need that 15. He doesn't need $15,000 a year in supplementary things. Although it could be used, with consideration, it could be used to even upgrade his bedroom and upgrade, like build a conservatory on a Carrie's Place property. It could happen. We'd have to talk about that. But what will probably happen is the 15,000 will accumulate, and his sister will keep it and accumulate it. And we have no reason to think that he won't live for another 20 years at least. So that's 15,000 times 20 years. That's 300,000, and it'll be invested. And then when he dies, he'll die intestate because he can't do a will. So he'll have no will. So he dies intestate. And what will happen is the guardianship ceases when he dies, just like a power of attorney. It's only effective as a guardian of property or person as long as the person is alive. So then he dies. There's no will. And his sister, his only sibling, will then apply to the court to become the executor of his estate without a will. So it'll be an intestacy probate application. And she'll be appointed by the court. And then by succession law, she'll inherit the money that has accumulated. And the same thing will happen with these RDSPs in similar scenarios. The brother has an RDSP, it's accumulated to $400,000. when he's 60. When he's 70, he passes on. The legal guardianship ceases. And by succession law, his siblings would inherit. Now, there's a whole succession law tree as to who gets it if so-and-so is dead, up and down, and then back around like this. And other than that, the tree is very simple. You just follow the tree and it tells you who gets it. And it's interesting because in some of these scenarios, if the child, say he has Down syndrome, and he's an only child, well, it could settle out that his cousins get it. And it could well be that these cousins don't know him at all and never came to visit and don't really care much about him. But by succession law, they could well be the ones to inherit. It's possible. It's very interesting.
Yeah.
Any questions so far?
There's a few Henson Trust questions building up. One is, how is a qualified disability trust different from a Henson Trust?
It's not different. A qualifying disability trust is simply a trust where the beneficiary has been approved for the disability credit. Excuse me. The Henson Trust is just a testamentary trust, but it has some specific aspects to it in the drafting that are uniquely different from other testamentary trusts. But in most basic ways, it is treated tax-wise and so on. It's treated as all other trusts, excepting that if the beneficiary or one of the beneficiaries, and I try to structure it so that there's only the one if I can, if the beneficiary qualifies for the disability credit, well then the trust can be deemed to be a qualifying disability trust. And it then, of course, falls under the old taxation rules, and the first $40,000 of trust income is taxed at beginning marginal rates of 22%. You know this. Now, in fact, the QDTs are interesting, and there will be scenarios where QDTs are used, but in practice, what's going to happen is you don't really want to pay tax at 22% in the hands of the trust, right? That's still 22%. You don't really want to do it. It's better than the top marginal rate, but you're still not that interested in paying tax at 22%. So what you do is, of course, you attribute the income to the beneficiary using what's called the preferred beneficiary election, which is available in particular if the child qualifies for the disability tax credit, which would allow you to then have a QDT. But what you're going to do is you're going to attribute the income to the child to use his personal tax credits, because he has a personal credit of 11.6, just like you, and he has the disability credit by definition of 8.4, so that's 20,000. So you want to attribute the first 20,000 of income to the beneficiary so there's no tax paid. And in most cases, 20,000 of income is going to cover the income of that particular trust. I mean, that's 5% on 400,000, 20,000. There are trusts that are greater than 400 that earn more than 5. That's true. But still, you're going to attribute the first 20, no question. And then if you attribute more, well, then it's taxed in the hands of the beneficiary at 22%. Now, if you want to opt to have it taxed in the hands of the QDT at 22%, go for it. It just, then you have two tax returns with taxable income.
Ruth is asking, what are the tax implications for having more than one trust? I have understood that there could be a significant tax rate for having more than one.
Well, here you get into multiple trusts and the fact that testamentary trusts that are not QDT trusts are taxed at the top marginal rate. So if you had $3 million trusts, I guess you'd probably wind up paying taxes at a higher rate than you might like. What you would do is you'd attribute income to the child, The first roughly $60,000 you'd attribute to the child for sure. Then you might use a QDT for one of the trusts at 22 points on the first 40,000. And then what do you do for the third one? I don't know. You know, that's a nice problem to have. So yeah, you could wind up paying tax at a high rate on one of these multiple trusts. That's true. You could.
In regards to a Henson trust in the deceased parent's will, do all assets and funds remaining in the Henson trust go automatically to the trustees upon death of the disabled person?
On the death, there's a distribution clause in the trust, in all trusts. And upon the death of the beneficiary, typically, you could drag it out to remain in place for his children, if you like, or his grandchildren. Right? You can leave it for a long period of time if you want. But normally upon the death of the beneficiary, the residue goes to his children, if any, failing that to his siblings, or failing that to a charity. And so that's what happens. Let's just carry on with some of these slides. It's 10:30.
Okay.
So what will happen to my child when I'm gone? That's the core concern. And of course, you need a Henson trust to receive an inheritance. And these are the factors that have to be taken into account. For example, a common question is, how much should I leave? Well, I don't know, but I can discuss it with you. And we can come up with a number that gives you comfort. And of course, if you happen to leave more than is actually going to be likely necessary, it'll accumulate. In most of these cases, it accumulates in a tax-free way, which is good because the first $20,000 of income is not taxed. So it accumulates, which is great. And then one day it's left to other family members or to some charitable cause, which is great. So, you know, even if you overfund the trust, if you feel better about that, that's great. But at the end of the day, it's all in the family anyway. You know, it could well be that it's simply a deferred inheritance of that 25% of the estate that is left in the trust for the child with special needs. And he's in a fully supported living situation, so he doesn't really need much of anything. But the first 20,000 is declared in his hands and accumulates tax-free. And then when he dies, it goes to all the grandchildren. Now, there's nothing wrong with that plan as far as I can see. Let's see. You want to do a poll? How many people have kids over 18, for example?
Okay.
What have you got there? You got 4 polls?
Yeah, I got the ODSP, Wills, DTC, and webinar.
What's the first one?
ODSP. Like who's on ODSP?
Okay, try that.
Okay.
We have some questions that we're going to poll, and if you would be kind enough to respond, we'll just see. It gives me a sense of who I'm talking to.
Okay. I have a question about the asset exemption or the ODSP asset limit from Terry. He's asking if the ODSP recipient has $40,000 in a bank account and spends some of that money, can that amount spent be replaced by a relative, and would that replacement money be exempt, or would it be considered part of the gift limit?
It's still subject to the 10,000 over 12 months.
Okay.
Yeah.
Great.
Now, you know, worst come to worst, if someone wants to give your child $40,000, then in the month they receive it, it's received. And there's an overpayment in the month received. So they're overpaid their benefits that month. They don't lose them. They've been overpaid. And what happens is ODSP says, oh, well, you got $40,000 last month. You're overpaid $11.51. So you owe us $11.51. And we're going to reduce your benefits by $50 a month until 1151 is recaptured.
Okay.
But that's the worst that happens.
So I'm going to close this poll and share the results. 70% have a family member on ODSP. 15% are just here looking to learn more about it. 8% are on it.
That's about what you'd expect.
Yep.
How does that number compare with Thursday? It's much bigger.
Yeah, it is. I think there was more financial advisors on Thursday because we had a lot of other on Thursday.
Right.
Yeah.
This is exactly what one would expect on a Saturday morning. It's largely the parents, perhaps siblings,
Yeah.
some people on ODSP, a few others. That's what you'd expect. Next slide, please.
Sure.
Okay, so the important point here is that what is it, 46,000 people that are boarders, they're normally slotted, almost invariably, slotted into 881, which is the room and board amount. And we can typically get that increased to shelter plus supplementary, which is the 1151. So that's what, $270, that's pretty good. So we can typically increase it by about 270. And the way we do this, one way we do this, is we do a lease between the parent and the child. And the child pays, let's say, $550 a month for rent or shelter costs. Now this rent, pursuant to the terms of this lease that we prepare, is not rental income for Canada revenue purposes. You would only declare this if you were in pursuit of profit, which you're not, obviously. So you don't declare it, and similarly, the child can't use it as a rental expense on their return, where they might get some kind of provincial property tax credit grant back. I know there's an amount that a tenant would receive that relates to property tax, and I think it's roughly $300 a year. But that doesn't apply to my clients, so that's why I don't know really much about it. Now what happens is we do the story of a day in the life, a week in the life of this child, and it's helpful if they're able to shop and cook, because if they can shop and cook, then perhaps arguably they're not provided with food, but of course in most cases, mom does make the food. If we can help them to have life skills so that they do shop and cook, then it makes it easier for us to get this benefit increase. But we're able to get the increase even if a person is in need of full care. And I won't go into all the details. It's a detailed argument, but basically, no, I won't go into it at this point. It's just too complicated. But we're able to get the benefit increased in almost all cases. I would say in the case of 24/7 care, 60% of the time. If you appeal it, if you decided to pay, you wanted to do a social benefit tribunal appeal, 99% of the time. And then with respect to simply submitting the lease, 85% of the time. And then from there, you have to decide whether you want to do a tribunal appeal or not. But normally we don't. As far as exempt assets, we have people who are receiving CPP disability benefits. And CPP is a higher medical test, because the test is you can't work at all, whereas the test for ODSP is that you can't function in a competitive workplace. So the test for CPP disability is a higher test. So medically, if you qualify for CPP disability, you automatically would qualify for ODSP medically. But of course, a lot of people on CPP disability have some savings, because by definition, they were working
Mm.
So they perhaps have some modest RRSPs, they might have a TFSA, money in the bank, some GICs, you know, not a lot, but, you know, more than, and until recently, of course, if what they had was greater than $5,000, they didn't qualify for ODSP. So I guess our help may be needed somewhat less, I suppose, now that the asset test is $40,000. But we can get people onto ODSP who are receiving CPP disability. So if you know anybody who's on CPP disability, in the past, typically what would happen is they would be told that they don't qualify for ODSP. They have to wait until they've spent their savings down to 5,000, which is unfortunate. Now they have to wait until they've spent it down to 40,000. But again, this isn't true. We're able to exempt up to 100,000 plus 40,000. So, you know, if you know people on CPP disability, you should have them give us a call.
There's a couple questions coming up in regards to having wills created for individuals with special needs. What is the criteria for special needs individuals being able to create a will? Was your previous example due to the degree of disability? I think people are unclear about whether they can have wills at all. Well,
people with special needs should often have wills, especially if they have RDSPs. Because, of course, the RDSP is their asset. And these RDSPs could easily accumulate to, say, $400,000 by the time this person is 60. So, you know, if they're competent to do a will, they should have one. And of course, one of the initial preliminary things that we do is whenever we do an assessment or intake, we determine if we do powers of attorney from the child to the parents. And if appropriate, we would include a sibling. So, you know, we assess the competence of the child. And for powers of attorney, we take the position that a low level of competence is sufficient because it's just a practical matter. You know, if they were unable to manage their own affairs, which they may well be, but if they're unable to manage their own affairs, do they know who they would like to manage them for them?
Yeah.
And if they do, which typically they do, they know that they want their parents to manage their affairs. And then failing that, they want their brother and sister to do it. You know, that this is a true understanding. Then we do powers of attorney for those people, those kids, because inevitably, of course, they're young adults, and the parents who for decades handle things for them, the day is going to come when they're asked by some doctor, some hospital, some bureaucrat, you know, that they have to have powers of attorney, because otherwise the child is a young adult, and you know they realize that the child can't properly answer certain questions, but they don't quite know what to do. So they ask the parent to have powers of attorney, even if the child is clearly not competent and couldn't grant powers of attorney. So, you know, then we have another interesting discussion. So that's the first step. But yes, they should have wills. And the question is, are they competent? Do they know what they're doing? Do they know who they want to leave what they have to? And it's a judgment call. And I can tell you that it's a practical thing. Like if they do a will that simply leaves everything, which would include their RDSP, to the parties who would get it by succession law if there was no will, well, then it's unlikely anyone's going to argue. And if they leave some chunk of what they have to a charity, and if the other parties who receive, such as their siblings, support this decision, like if you, I see a young man died and his obituary was in the paper today, and they suggested donations to Wise Owl. Well, that of course would be a wise thing to do, to Wise Owl, to leave money. But if his will left money to Wise Owl, and the rest of it was left to the siblings don't argue, I would go ahead with that will.
Baba's asking if an applicant is denied ODSP because they possess an asset that's gone up in value since the application was made, taking them over the 40,000 asset limit. Can they reapply right away once they're back below the limit, or do they need to wait?
No, right away. But you can't dispose of the asset in order to qualify. You have to have legitimately dispersed the money in some way. You can't just have given it to your mother. But if you have not disposed of the asset in order to qualify, then yeah, right away.
Greg had an interesting one. Is it possible to open up a Henson trust now, or do they have to wait until after death?
You could set up what's called an inter vivos Henson trust. And we do these typically to hold houses, condos, houses for the child to live in, or to receive an inheritance from a grandparent or an aunt, where the grandparent or aunt knew that they really should have a Henson trust in their will for the money, like 250 grand, that is being left for the grandson, but they just don't do it. So it could be appropriate to set up an inter vivos trust to receive the 250 grand that was given to the parents, but was really intended for the son, the grandchild, in order to endow this trust so that the investment income is then taxed in the hands of the grandson. And of course, the money is then tucked into this trust and earmarked clearly for that grandson. It's not just sitting in the parents' hands to be then settled into the trust from when they die. So there are circumstances where you could have an inter vivos trust. Most often to hold a home, condo, a small house, but it's not common.
You want to take another one? Rhonda's asking if an adult child works part-time sometimes, can they still be on ODSP?
This is ODSP and employment income. And the rule is that, yeah, you should work. The child should work. Work is good. Work is social. And the way that works is what are the current rules? And just sometimes I got to recycle myself and make sure I'm on the current rules. If the child works, ODSP gives them an additional 100 a month. And then the first 200 of employment income is exempt. And then every dollar after that, they lose 50 cents. But otherwise, they stay on ODSP.
Okay.
Could you go to the next slide?
Yeah.
Okay, so tax credits. Now, one of the things we commonly do is we deal with disability and caregiver tax credits. And we do a 10-year recapture. And the recapture for the disability credit is typically $16,000, and for the caregiver, it's $7,000. So for one of those 46,000 border clients where they've just never used the credit because somebody told them, oh well, I don't think he'd qualify, and we get this. Some doctor says, oh well, no, I won't fill out the T2201 because your son won't qualify. Well, it's just not his goddamn choice. Fill out the form and we'll deal with Canada Revenue. It's not your decision as to whether that child qualifies. That's just my exasperation coming to the top. But these are the typical recaptures. A common scenario is where the parents used to use the disability credit, but then the child went into supported living. They've been there 15 years, and 15 years ago, the parents quit using the credit because they were told that the child had to reside with them, which is not true. And Chris Jan, you want to poke your nose around the corner? This is Chris Jan. She does all the tax credit adjustments as well as certain other things. But this is the most typical recapture. Now, the caregiver credit, unlike the disability credit is transferred. It's the credit of the child transferred to the supporting parent. And if the child resides with the parent, then clearly it's transferable. And if they don't reside with the parent, if the parent helps them to some extent with the necessities, food, shelter, clothing, well, then the credit is transferable to the parent. So, this is a common scenario. And of course, if the client says to me, no, well, he lives on his own, and no, we don't really help him. He's very frugal. He buys all his own clothes. Well, what we do is we discuss starting to help the child, paying his hydro, say $100 a month. Well, if you pay the hydro, then clearly you're helping with shelter costs, and the disability credit, which is $1,600, is transferable to you. So this is a very simplistic example, but you can see that if the parent pays $100 a month, $1,200 a year, and they're then able to use a credit that they didn't use before, which reduces their taxes by $1,600,
yeah.
I don't see that we need to carry that discussion a long way. And the fascinating thing about the caregiver credit is that until 2017, the criteria for it was that the child resided with you, was older than 18, had income less than $17,000, and of course ODSP was 13,600, and that they had a disability. Well, as of 27, so this means that it's just the people living with parents, right? Or with a sibling, the 46,000 boarders, for example. But what's happened now is that as of 2017, the reside with criteria has been removed. So instead of the 46,000, it's the 60,000?
Yeah.
It's the 360,000, because I think it's fair to say that the parents of the 360,000, with certain exceptions, the parents help those individuals, and the caregiver credit applies once if you remove the reside with criteria. So what we've got here is very interesting. It reduces taxes presently by about $1,000 a year, and it's now going to start to apply to, I would say, almost all of the 360,000, whereas before it applied to 46,000. So that's 320,000. And what it's going to do is it's going to reduce the taxes of the 320,000 by $1,000. So you've got 320,000 times 1,000. That's a lot of money.
Mm-hmm.
Every year going forward, starting with 2017. So on your 2017 tax return, the other 320,000 people should seriously look at line 315, the caregiver credit. Any questions?
Yeah, I got one from Herb actually.
Oh.
He has a prospect client in his 50s who was denied for Canada Pension Disability because he was trying to be a special needs Olympic athlete.
Oh.
Can anything be done? Can CPD be backdated?
Well, in order to qualify for CPP disability, you have to be unable to work at anything. So if the issue, well, if you're a Special Olympics athlete, I don't think you get paid. I doubt it. So I don't see that it would be the conflict with employment as a Special Olympics athlete. But the test is that you can't work. I think you're allowed to make $5,000 a year.
Okay.
Something like that. But otherwise, you're just can't work.
And can it be backdated?
Well, if you appeal it,
Yeah.
And if you should have been approved,
Right.
and on appeal you're approved, well then yeah,
Then
you do
you-
get a lump sum retroactive amount.
Fair. Okay.
But that person probably would qualify for ODSP.
That's true.
You know, and an ODSP is always greater than CPP, plus it has drug and dental coverage.
And ODSP, just tying this into another question here, it's only good until 65, right?
That's correct. And then,
Yeah.
but what happens then is you get old age security and guaranteed income supplements, which are roughly 17.4 compared to 13.6 for ODSP. So,
Okay, so
you know,
things
and
get better.
you get your drugs under the Ontario Drug Benefit Program because you're a senior, just like all seniors. So,
Right. Okay.
okay, the second part of this slide is RDSPs. If a person is approved for the disability tax credit, then the child who is approved for the disability tax credit qualifies to have a registered disability savings plan. And if say the child's 18 and older, so based upon their household income, which is ODSP, if someone contributes $1,500 a year, the government, federal government, contributes $4,500, and they do this for 20 years up until age 49. So you contribute $30,000, the government contributes $90,000. That's 120. And if the money was invested at 5%, because it'll be invested, then 30, 90, 120 invested at 5% over 20 years, it's 200,000 at the end of the 20 years. So at that point you cease contributing because there's no more matching grants and bonds, and the kid is 38, let's say. So 200,000 invested at 5%, that's 10,000 a year. Every decade it's 100,000. So 48, 58, because you're waiting until the child is 60 to start to receive money. So it's then 400,000 when the child is 60. And so, of course, you should consider having a will for the child. RDSPs, unlike TFSAs and RRSPs, are not designatable. I'm not quite sure why that's the case, but that's just how it is. So, you know, again, it's a question of intestacy, perhaps, and succession law, or having a will to designate where the residue of the RDSP goes when the child dies.
I just did the poll for DTC, and 32% are using the DTC on behalf of a family member. 16% are using the DTC for themselves. 16% have a family member using the credit. 22% are here to learn more.
Is that right? Can you just go over those numbers again?
Yeah.
Because they add up to a big number.
Yeah. So 32% of listeners are currently using the DTC for a family member.
Yeah.
16% are using it on themselves.
So that's 33.
Their own DTC.
So that's 33 and 16.
Yeah.
Okay.
And then another 16 are using or have a family member using the credit.
So, okay. Someone else.
Yeah. 22% are here to learn more.
Huh.
6% are trying to get someone else approved.
I'll be darned.
Yeah.
Well, what I think, and I've just used sort of simplistic numbers, I would say at least half of my clientele, the children are approved for the disability credit, or certainly should be.
Yeah.
Now, you know, we have, I wonder how many files you have. I don't know, but we have a lot of files where we are seeking or re-seeking the disability credit approval and doing the adjustments and so on.
Yeah, like active currently, I have about 75.
Okay.
Yeah.
So it's an ongoing, you know, continual process for us. I'd like to point out that you don't have to be approved for the disability credit to use the caregiver credit. We've had situations where someone thought they could only use one or the other, or they couldn't use the caregiver because they weren't, the child wasn't approved for the disability credit. So but that's not true. So of those 340,000 or 20,000 people who are the parent or sibling of people on ODSP who would now like to use the caregiver credit, they don't have to be approved for the disability credit. They just have to have a disability. You have to have a Schedule 5. That's part of your application to use this.
Scott Dunn is asking, what is the maximum contribution per year for an RDSP?
Well, there's no maximum each year, but the optimum would be $1,500. $1,500 gets you the $3,500 grant, and the child gets the $1,000 bond anyway. So $1,500 gets you $3,500. If you're late in setting up the RDSP, then there are certain optimal numbers to back contribute, retroactively contribute, to pick up the money, the grants, because the child gets the bond anyway. Like if you open an RDSP now, a new one, the child's going to get 10 years worth of $1,000 bond, regardless. But if you want to pick up the 10 years worth of $3,500 a year, well, then of course you have to contribute to get it. And there are certain restrictions, I won't go into them, but there's certain optimal numbers to pick up the retroactive contributions. But normally going forward, it's $1,500.
Christina's asking what happens to an RDSP when you're no longer eligible for the disability tax credit. Can you roll it into another investment, or does the government payments need to be paid back to the government?
The RDSP goes poof. The child gets the money you have contributed because they're the beneficiary, and the government gets their grants and bonds back.
Maybe mention, like, you can get, you have a time frame to get
that's a good point.
reapproved.
Yeah, you'll be led to believe that you have 1 year, but in fact you have up to 5 years to get the disability credit reapproved and back in place. But you have to request that the institution that's holding the RDSP wait for this period. Okay, next slide. It's 11 o'clock, so that's the first hour. Now we're talking about powers of attorney, guardianship, and substitute decision makers. The first one is simple, and that is powers of attorney. Most of the kids, lots of the kids, half of the kids can properly sign powers of attorney because they have a sufficient level of competence to understand what they're doing. Sometimes they can only make their mark. Sometimes some people have a stamp. Sometimes, realistically, the parent has to help the child hand over hand. We're just being realistic here. But for those who can't sign powers of attorney, if the only issue was medical care, then there's another tree. There's the succession law tree, and then there's the substitute decision maker tree. And it determines if the child is incapable, who is the substitute decision maker. And in practice, it would first be the parents. Now, the practical aspect of this is that if it's just healthcare, the substitute decision making is just healthcare, not property, not RDSPs, then what we do to assist the family is we have a substitute decision maker package, and it looks very legal. It's spiral bound. It has my letterhead and my opinion, and in bold letters it has the informed consent on the first page, and it's got a clear front cover, so that the doctor or the hospital that sees this spiral-bound bundle, which has affidavits and copies of certain legislation and so on, what they see, the first thing they see, is my letterhead and informed consent. And what this does is it puts them on notice liability-wise, that they can't just come up with the two types of treatment that they think are best for that child and take it or leave it, because that's what happens. There's no question that there's a bias, there's a discrimination against people with disabilities and old people. And anyone who has a child with special needs, or who is an old person, or has a family member who's an old person who has health issues, realizes that there's a discrimination against people with special needs and who are old. And it's sort of it's engendered by the standard triage system, where everybody's divided into one of three groups, triage, right? And, you know, can't fix you, probably can fix you, yeah, we can fix you. Well, doctors and hospitals, as caring as they may be, as supportive as they may be, you can't get around the fact that there are situations where there's a shortage of resources, a shortage of time, and where they look at people with disabilities and old people as broken bicycles. And if you're a broken bicycle, why fix the tire? And you'll inevitably find this. I won't go into the stories right now, but that's just how it works. And if you have a substitute decision maker package, what it does, we do the multiple copies of this, so you can, you know, give these weighty bundles to various people. What it does is it makes clear that you have legal advice, you're aware of the need for informed consent, not just saying, oh, okay, doctor, you know, if you say so, but informed consent as to what is the best process, what are the processes, what are the alternative processes, and what is best for your child. So you'll find you get more attention, better care. Now, if it's more than just medical, well, then you need legal guardianship. And what this does is it's an application to the court. There are two capacity assessments. So there's legal fees for capacity assessments, court filing fees, public guardian review fees. So, you know, it's not inexpensive. But there are clearly cases where it is clearly the thing to do. We started doing these back in 2009 because, of course, prior to that, before RDSPs, there could be medical issues, but people on ODSP didn't have any assets. You know, there was no property to talk about. So, you know, we could often get by with a substitute decision maker bundle, but now that's changed. Now, of course, what happened was in 2009, if you were incapable and you wanted, you know, incapable but obviously approved for the disability credit, you couldn't have an RDSP because you were incapable, and there was nobody with legal capacity to set one up for you. So you needed legal guardianship. And then in 2010, I think it was determined that parents can be the account holders for an incapable child. So that's good. And it's been extended for a period of time. Now, originally the intention from the federal perspective was that they would allow the parents, no one else except the spouse of the person with disabilities, which, I don't know how many spouses people with disabilities have, but for the parents only, really, and to allow the provinces to perhaps lighten up their guardianship provisions to make it easier for people to become legal guardians, but that never happened, and I don't see it happening. It didn't happen, and I can't see it happening. So I think it'll probably continue with parents, but of course what you want in a lot of these cases is some other appropriate person, such as a sibling, because when the parents die, what happens is the child is still alive, money is not yet vested, and you have to have an account holder, and if there's no account holder, the parents are deceased, then the RDSP evaporates, and the government gets their grants and bonds back, and the kid gets the money that the parents have contributed. Whereas if someone such as a sibling could be the account holder, they could step in and become the account holder, but that's not the case. So this is one reason that we set up the powers of attorney to the parents and then as alternates to the siblings, and that is to manage these RDSPs. But that's also why you need guardianship, because if the parents are deceased, if a sibling is a legal guardian, then they are the legal representative of the child, and they can step forward and become the account holder on the RDSP. Are there any RDSP questions?
There's one here. She's saying her son is on ODSP. His RDSP is in her name because if he knew about it, he would try to get it. Yeah. She has legal custody of his children, and she's saying if he had a will, would he find out about the RDSP?
No, if he had a will, it would just leave, one presumes, it would leave all to his kids. She has custody of his kids.
Right.
Yeah, if he had a will, one presumes it would leave all to his children.
Okay.
And I understand and respect the fact that you're being discreet, that you're not telling him about it, that you are the account holder. Got that part. Sounds like she's got things under control. Mm-hmm. Not that it's easy. It's obviously not easy for her, mm-hmm. But sounds like she's got it under control.
Terry's asking if you can start an RDSP for your child before they have been approved for the disability tax credit.
Yeah, you don't have to be approved to set one up.
Okay.
We'd have to talk about, what scenario would make that useful. But yeah, you don't have to be approved. The only other angle is that if you set up an RDSP before the child's approved and you happen to put money into it, and then one day you want the money back, like they never get approved, there's no mechanism. Well, it's a very awkward mechanism. You can't just take your money back.
You have to wait for...
Well, you have to find a way to collapse the RDSP, which was never authorized.
Right.
Basically, if you put the money into an RDSP prior to disability credit approval, and then you want your money back, it's difficult.
There was one from a while back there. Fitz was asking, can a rental property or second home be left in a will in a Henson trust?
Absolutely, yeah. I have a client family up the valley up here, and they have several kids. They're older now. I'll have to see how old they are actually, but they were very young when the parents came in, and they had disabilities, and the parents bought it was a triplex across the street, and the plan is that by the time the kids are old enough, well, by the time the parents die, that the children will stay in the family home, because there's 3 of them, mm-hmm. and that they will be subsidized by the rent from the triplex across the street, which has a mortgage that is now paid off. Now, you can talk about all the details of this plan, but that's a plan, and it would work. Okay. Yeah. Now you do have to keep in mind that with these kinds of properties, no, I won't go into that.
Okay.
But yeah, that can happen. That can work.
I see two very similar questions here. One is asking their husband's name is on the RDSP. How can they get their name added in case something happens to the husband? And the other question is, can the RDSP plan holder be changed from parent to sibling?
Well, first question, how do you, what do you do as far as the parent, the husband?
Yeah.
Well, there are boxes for 2 account holders.
Okay. So you can have 2 account holders.
Yeah. So
Okay.
that's okay.
All right.
And then as the other one, the other account holder can't be a sibling.
Okay.
It could be the sibling if there's a power of attorney.
Okay.
But otherwise, no, they're not an approved account holder. And that's the problem.
In regards to substitute decision maker that goes to the parents of a child with a disability, what happens in divorce if the parents are not speaking with each other? Who would be the decision maker?
It's awkward, but they're still the 2 substitute decision makers.
Okay.
And you're right, it's awkward.
Can a sibling be designated as a legal guardian when the parents are still alive?
Yes, and typically these guardianship applications would be an application to appoint the parents together with siblings. You can't have alternate siblings. You know, you would sort of think that you might be able to have the parents, and then if they can't or they're dead, someone alternate, but you can't do that. You have to have them all at the same time. Can you go to the next screen?
Sure.
Okay, this is pensions for adult dependent children. And what this deals with is if you happen to be a teacher, could be a university prof, Algonquin, but you're a teacher, or you're a municipal employee, or you're a hydro power generator, Bruce Nuclear, then you'll have a pension when you retire. If you have a spouse, you die, spouse gets, let's say, 2/3 of the pension. And then the spouse dies. Well, these adult dependent survivor pensions will fall down to an adult dependent child. Now, it's only for these categories of pensions, and these are what are called provincial statutory pensions. Excuse me. Provincial statutory pensions. You can see this, provincial statutory, and they're pursuant to statute. And my experience is that they're in all provinces because, of course, all of these categories of workers are unionized, and so of course the unions in the different provinces talk to each other, and the benefits are largely the same, or at least they argue for them to be the same or more. So. In Ontario, in particular, you know, my main category, what happens is, we discussed this briefly earlier, the parent who's a teacher, 84, $60,000 pension, son, 54, severe autism, living in Carey's Place, full supported living. Well, you have to deal with the issue of dependence. So if you have the child who's living with you, then they're dependent. If they're not living with you, then how do you make sure that they are sufficiently dependent when you die for them to get the pension? And what you do is you have to come up with a scenario where you're helping to some extent with the necessities of life, food, shelter, clothing, even though they may not reside with you. And there are certain other pensions, private pensions, that also would fall into this category. So, for example, Aviva Insurance, Bank of Nova Scotia. In some cases, if there's no spouse, there's a pension, there's an actuarial calculation for a pension for a survivor, a dependent survivor. And if there's no spouse, well, then it applies to the child. And the question is, for all of you listening, is if you think that there might be or want to find out if there is such a possible pension for your child, because of course, if you have a 60,000 pension and your child is going to get 30,000, this is a big part of an estate plan. Because for one thing, it disqualifies ODSP. I've said this before. So the thing to do is to go to your human resources, your pension people, and say, I have an adult dependent child. They're this age, here's their SIN number, here's the nature of their disability, they're living with me, they're dependent on me. They couldn't survive without me, regardless of whether they're living with me, they couldn't survive without me. Is there an adult dependent survivor pension for such a child? And find out. And I'd be happy to hear, because of course we have my clients ask this question all the time. And you know, I have them ask repeatedly, even when I think I already know the answer, because I've had 6 people ask that question to that particular employer. You know, at a certain point I give up. But I make it clear to the client, when you ask this person that works, you know, at this, you know, in this human resource department, the fact that you ask the question and they say no, that doesn't mean they're right. They may think they're right. You know, they may, you know, brush you off and say, oh no, there's no pension like that. You know, they've never heard of it, they've never seen it. Well, that doesn't mean it doesn't exist. And it also doesn't mean that if you don't ask that you can't get it. Because with Aviva and Bank of Nova Scotia, you know, you may well go to the human resource department and say, is there such a pension? And they tell you no. And then when you look into it and you talk to your employer, you say, well, why not? There's a pension for my husband if he was still alive. Why is this pension not available for my daughter? Well, okay, all right, well, we'll give it to her. Now, it's not obviously that simple, but that is how the world works. Any questions about that?
No.
Okay. The interesting thing for me for those plans, well, I want that slide, but no, that's okay. That's okay. I want that slide. Right. The interesting thing for me is that if you stop and think about how many people there are in the province, I'd like the numbers if anybody has them. How many teachers, how many professors, how many municipal employees, how many hydro, Bruce Nuclear employees? I would love to know what that number is compared to 13.7 million or 4 million, whatever it is, households. I would love to know what that number is, what proportion that is. Okay, RRSPs, Lifetime Benefits Trust Plan Giving. Now, of course, you could roll over an RRSP to a child who has special needs. But of course, this does a couple of things if you did do it. Firstly, if it's greater than 100,000, it will disqualify them from ODSP. Secondly, could they manage it? If they could, arguably, if they could manage it, would they find themselves with other people helping them manage it? Would the people that are helping them manage it be people you want them to help manage it? And this does make it their asset. Do they have a will? So these are all important factors. And yes, you could designate it to them, and they could direct that 170,000 of it be put into their RDSP if they have one. Yes, those things all can be done. And I'm happy to discuss all of those things with you as part of your plan. But what I'd like to talk about is Lifetime Benefits Trust. Now this is a, excuse me, this is a special type of trust, which I've been working on since 2003. I finally received royal assent in 2013, although it had final reading in 2003. And the way it works is this. It's a separate parallel trust to a Henson trust. It's not a Henson trust. And it is designed, in particular, to receive registered funds, RRSPs and RIFs. And it's especially useful for people who have adequate other income, so they don't really have to draw upon their RRSPs and RIFs, such as other pensions or investment income, and who don't have a spouse to pass it to. Now, we've just finished one, where both of the parents are still alive, and so we've planned accordingly, But basically, you're planning for a scenario where there'll be a surviving parent, and they have adequate other income, and they have a reasonably sized RRSP or RIF. Now the RRSPs and RIFs that we're working with, they vary in size. The technique is valuable even in the 200,000 or 300,000 range. A lot of the ones that we're working with are 500 to million. But basically, if it irks you to think that if you die and you have a $300,000 or a $200,000 RIF, that half of that money is going to go to the government, if that, you think that you've worked hard and you've lived frugally and you've invested your money in your RRSP, and you think it's really unfair that the government should get half and your estate should get half, your children should get half. So you can obviously see my perspective on this. If you think that that's inequitable, no matter how big the RRSP is, then you should consider a lifetime benefits trust, because what happens is you designate the RIF to the lifetime benefits trust. It's received by the trustee. So you don't have to worry about it being the asset of the child or managed by the child. And the only thing they can do with this is buy a qualifying trust annuity. So what they do is they take the 300,000 or the 500 or the $1 million, and they buy an annuity based upon the life of the child. So it rolls over to the trustee. It's deferred the same way it would be if it was left to a spouse. The trustee purchases the annuity, and what we do in practice is we put a guarantee on the annuity. So let's just say that it's $1 million RIF, and you don't want to lose $500,000. So you set up the lifetime benefits trust. The trustee purchases the trust, the annuity, and it pays $50,000 a year. Well, what you would do is you'd have a 30-year guarantee. Now, it could be slightly less, but if you have a 30-year guarantee and it pays $50,000 a year, then you know for a fact that the annuity will continue to pay $50,000 a year for 30 years, which will return $1.5 million to the trust. And it will continue to pay if the child lives longer than a further 30 years, whatever that lifespan of that child is. And of course, if the child, we would at that time see if we thought that child was going to have a likely lesser lifespan, because of course you would have a rated annuity, which then could increase the annual payment. But that's another discussion. So we have a guarantee period that guarantees at least the amount of the payment. They say the $1 million. So that'd be a 20-year guarantee. The $1 million is returned, and what happens is instead of losing $500,000 right away, the $50,000 is declared as income automatically, just automatically attributed to the beneficiary, the child. Now the child, in these cases, typically, they will have a personal credit of 11,600, just like you. Everyone does. And then they would typically also qualify for the disability credit. Now there could be cases where the child has cognitive disabilities, because for this to work, the beneficiary must have cognitive disabilities. It's not effective if the child is simply in a wheelchair. It has to be cognitive. But if the child has cognitive disabilities, there could be cases where they are not approved for the disability credit, but typically they will be, which means that they also have the disability credit, which is 8,400. So total of 20,000. So you've got 50,000 of income, 20,000 not taxed. The next 30,000 is taxable. It's attributed to the child, so it's taxed in the child's hands, but it's taxed at 22%. So that's $6,600. And if you have a 20-year guarantee, to guarantee the million is returned at 50,000 a year, then it's $6,600 a year over a 20-year span. So 6,600 times 20, 120 plus 12, is that right? 132,000, something like that. What's 6,600 times 20? Is it, let's just see here. Yeah, pretty good. 132,000. So instead of 500,000 immediately, you pay 132,000 over a 20-year period. That's not a bad plan. That's as low as it could possibly be. So, and what you also have is the guarantee that for the lifespan of that child, that the trust is receiving $50,000 forever until the child dies. So if you have other plans, such as having that child set up in a house, or wanting that child to have an adequate lifestyle, I think $50,000 minus $6,600 in taxes, I think that's going to do it. And it does not disqualify ODSP on the face of it, because it's an attributed income to start with. It's not actually received by the child, it's received by the trust. Any questions so far about that?
There are a couple simple ones here. For a lifetime benefits trust, can other children be paid out of the annuity or only the special needs child?
Just the special needs child.
Another one, can a grandparent transfer their RIFs to the lifetime benefits trust for their grandchild?
Yeah, grandchildren qualify. Yeah.
In respect to the survivor pensions, if a son was on ODSP and then started receiving a survivor pension, is there any estate planning strategies that could be implemented to allow him to continue receiving ODSP?
No.
No.
No, it's a pension, a personal pension received by that child. And it's just like any other pension, CPP, LTD, W, Workman's Comp. It's a pension received by the child.
Okay.
Yeah. I mean, there's a scenario, I would love to do this. I haven't been able to do it yet, but there's a scenario where it would be possible to have the pension that the child would receive commuted to a lump sum. So instead of a pension on a monthly basis, they would get $200,000. And one of these days, I'm going to have a chance to do this deal. But what you do is you go to the actuaries and you say, look, here's the scenario. You never knew, you didn't even know about this child. You know, you haven't planned for this child. This is an unfunded liability, right? You never planned to have a pension for this child. And they're going to get $500 a month, but all it's going to do, because it's an owner's pension, all it's going to do is offset ODSP. So it's no good to my client either. Now, $500 a month is $6,000 a year. And this child is of this age, And actuarially speaking, they're going to live this long. So that's 6,000 a year times 20 years. That's 120. I'll tell you what, make you a deal. You give me 60. Give my client 60. Forget the monthly pension. Give them 60 grand. You would otherwise have to pay 120, right? Actuarially speaking, and you're an actuary. So I'll cut a deal. You give me 50%
as a lump sum,
and we'll forget it. All right.
And then you exempt that money.
Yeah, exactly.
That makes sense.
So I would love to do that deal, but I just haven't had the tax situation yet. I've got one in Picton where that I think it could work, but you have to have this planned in advance before the person retires. Once they retire, it's too late.
Right.
But I've got one couple in Picton where I think this plan would work.
Fitz is asking, does the income from the Lifetime Benefits Trust disqualify beneficiary for ODSP at 50K? I would assume.
No, because the income is received by the trust. It's attributed and declared in the hands of the child. Yeah, that's true, right? But that's just like a preferred beneficiary election. It's attributed, it's declared in the hands of the child, but he doesn't actually get it, right? It's received by the trust.
Right.
So no, it doesn't affect ODSP. I mean, if you disperse it, it could affect ODSP.
Okay, that makes sense.
Next slide. It's what time is it?
11:30.
Okay, we're getting there.
Yeah.
So time to talk about Henson Trust. A Henson Trust is a testamentary trust, just like all testamentary trusts. But it has certain clauses that are specifically unique that make it different from a standard trust. And as a result, whatever amount of money you leave to it, whatever amount of money that is dispersed from it, I don't usually get this dry until about 2 in the afternoon. But whatever is left to the trust is fine, it's unlimited. And if you go to the next slide, what the trust has to have is at least two clauses. There's more to it than this, but 2 unique clauses. One is it has to provide absolute and unfettered discretion for the trustee and a non-vesting provision for the asset. So people ask me, well, my trust doesn't say Henson Trust. Well, we put Henson Trust in the wording of ours so that the client can clearly see that it's, a Henson Trust because we did it. But what it has to have is wording that makes it a Henson Trust. And a normal trust, the trustee has discretion, but it's a discretionary trust. And they could be compelled to give more money to the beneficiary. And you can appreciate that a lot of these trusts, especially if they're really what are called spendthrift trusts, the beneficiary figures they should get more money. That's always the case. They think they should have more money. And normally a trustee could be they could be compelled to give more money, but not a Henson Trust trustee, because they have an absolute and unfettered discretion. And they cannot be compelled. So it's just a non-starter. And now the only downside to this is that if you pick the wrong trustees, and they do in fact, they're just parsimonious and they don't give as much as they really should. They're not as generous, let's say, as the parent would have been. You don't have any option. There's no second chance on this. So you have to pay attention to who the trustees are. Occasionally, we'll find that the trustee is not naturally enough a sibling. But if it then turns out that those siblings have always fought, and the fact that the trustee sibling now uses this as leverage to prove his own situation and, lord it over the beneficiary, well, obviously that's not what you want. And I find that parents, they know whether this is going to happen. And then we discuss the multiple trustees. And of course, you have a potential conflict of interest because the siblings typically receive what's left. Well, if that's true, and if the siblings are the trustees, then how do you know that they're going to be sufficiently generous if they get what's left? So you always have to have that discussion. And then the non-vesting shall not vest. In a normal trust, the asset of the trust beneficially belongs to the trustee. It's just in the hands of to the beneficiary. It belongs to the beneficiary, but it's in the hands of the trustee. Well, in a Henson trust, it's in the hands of the trustee, but it does not belong to the beneficiary. It ultimately will vest in whoever gets it when they die. So you can see that even if you applied to the court's not going to give you the asset because it's not vested in you. It's specifically not vested in you. And the only interest they shall have shall be the amounts actually paid to them or for their benefit. Because in fact, it vests in their siblings or their children when they die. So you can see that if there's an absolute discretion and a non-vesting provision, this provision is strong enough that a person could file for bankruptcy and it wouldn't be affected. And they can divorce and the asset is not affected, which can be very effective. Because we have situations where that's actually the issue. The size of such a trust is unlimited. There's no limit to the number of Henson trusts that there can be for such a beneficiary. You can have multiple beneficiaries of the Henson trust. We have certain scenarios where due to the family situation, this trust is in fact for the child with special needs plus his brother. I won't go into further details, but you can see where you could have a trust and it has more than one beneficiary. And disbursements from the trust are basically unlimited. There is no 10,000 over 12-month limit. It's a common misconception that a Henson trust can only disperse what is allowed by ODSP, such as the 10,000 over 12-month amount. And it wasn't uncommon for people to say, well, ODSP will only allow 6,000 over 12 months. What good is it? 500 a month. My child wanted to disperse a lot more than 500 a month. Well, it's just not. It's not subject to that rule. I'll go into that to some degree if you want, but there's a technique to how you disperse the money so that it doesn't affect ODSP. And that, I did an article for Advocate Daily, which was then included in the last newsletter, which I think everybody probably saw. And the question was, how do you determine if the lawyer you're dealing with is sufficiently experienced with Henson Trust to do a proper job? And that was my point. What you do is you ask them, how does the Henson Trust trustee disperse money without affecting ODSP above the 10,000 rule? Because if they don't know how to do that, they obviously have not done it.
Right.
Okay.
Dawn is asking, is it possible to replace the trustee?
No. Now, that said, my trust arrangements have provisions for trustees to be replaced, because there are circumstances where you have to replace trustees and you want to replace trustees. But what he means is, if you're the beneficiary and you want to replace the trustee, can you replace them? Well, no, you can't.
Okay.
We have scenarios where we've been able to negotiate the replacement of a trustee, or actually negotiate the disbursement of the money. But could you oblige the trustee to remove themselves? No, you can't do that. That's just a non-starter. What you have to do is you're going to be such a pain in the ass that they don't want to do it anymore.
Is money paid out of a Henson trust considered under the gift limits of ODSP?
It certainly could be. And if the gift limits are adequate for your needs, great. Right? If 10 grand over 12 months is enough, which it could be, fine. But otherwise, there's no limit to what can be dispersed.
Okay.
Any other good ones?
There was one about RDSPs. What happens when you turn 60? What happens to your RDSP at that point?
It just starts to give you money.
Okay.
There's a formula much like a RIF, and at age 60 you start to get money. And we're starting to get these payments. People are turning 60. Comes as a shock, generally speaking, to the sister or to the parents, because the checks are simply issued directly to the beneficiary and they're sent out, and the beneficiary gets this check, and if they're able, they stick it in their account and then they spend it.
Mm-hmm.
Okay, testamentary trust changes. 11:45. So qualifying disability trusts. The rules are changed. It used to be that testamentary trust income declared in the hands of the trust was taxed at the beginning marginal rates of 22%. So of course you could have multiple trusts, multiple low rate taxation. This is very advantageous. That is all gone. So now testamentary trusts on the face of it, with two exceptions, are taxed at the top marginal rate, which is slightly over 50%. And of course you don't want to do that. So the exceptions are the graduated rate estate, which is, you see top rate taxation, graduated rate estate, an estate trust. The first 3 years, it is taxed at the lowest rates, and then it's taxed at the top rates. So, if you can settle up and distribute an estate within the first 3 years, if there was estate trust income, it's taxed at the lowest rate, which is 22%. Now, of course, you can always attribute income out to the beneficiaries, but the beneficiaries, except for the one with special needs, probably pay more than 22% on their own income. Then the second major exception is that if you have a testamentary trust and the beneficiary qualifies for the disability tax credit, that trust can be a qualifying disability trust. And a QDT, if you decide to declare income in the hands of the QDT, it pays tax at beginning marginal rates. So basically the first $40,000 or $45,000 of income is taxed at 22%. Now, I think I briefly covered this before, but what you're actually going to do is, by definition, this trust has a beneficiary approved for the disability credit, which means that you can clearly use the preferred beneficiary election to attribute income from the trust to the beneficiary. And of course, the beneficiary has personal tax credits of 11,600, and then for the disability credit of 8,400, so that's $20,000. First $20,000 of income attributed to the beneficiary is covered by their personal credits and their disability credit. So the first $20,000 is not taxed. I think we touched on this with the lifetime benefits trust, and then the other income is taxed at 22% in the hands of the beneficiary. Now there will be scenarios where you've got multiple trusts and they have lots of assets and they have high income, and you'd like to have one of them a QDT. That scenario will occur. But for the most part, you're going to actually attribute income to the beneficiary to use their personal tax credits. So instead of paying 22%, you pay 0 on the first 20,000. The unfortunate part is that all of the Henson trusts for kids who don't qualify for the disability credit, they don't qualify for QDTs.
Right.
And what also changed in October 2016 is that if you had an inter vivos trust that held a house as a principal residence for the child to live in, that principal residence capital gains tax exemption has disappeared. So we're going to have to do, I've got some creative alternatives that I'm working on here. But basically what's happened is the principal residence exemption for inter vivus Henson trusts has been removed and is now an issue. But a testamentary QDT trust still can hold a house. And Judy, this is the QDT arrangement. So if it's a trust after a death where the beneficiary qualifies for the disability credit, it can still hold a house, which will qualify for the principal residence exemption. Next slide. Okay. This is a link to the regulations that deals with the changes to the 10,000 over 12 months and the 40,000 asset test. Next slide. This is just the fact that the monthly benefits have increased, that the payments over 12 months has gone to 10,000, asset test is 40. If it's a couple, it's 50. Next slide. A portion of our practice deals with exempting assets that are received as a result of a personal injury, a pain and suffering award, or a Family Law Act award, loss of parental care, that kind of thing. Well, as of, what was it, September 1st? August 1st. As of August 1st, pain and suffering tort settlements and Family Law Act settlements, the amount of the settlement is exempt. Used to be that the first 100,000 was exempt, but the rest was not. So we had an active part of the practice here, finding ways to exempt all the rest of the money. Well, the tort settlements and the family law settlements, the basic amounts no longer need to be exempted because they are exempt. But this doesn't deal with statutory accident benefits. It doesn't deal with all of the excess money for other medical care, transportation, those kinds of things. So we're still involved in these types of settlements that, for the parts that are not tort, not family law. Okay, do you have any more questions?
Yeah. Can money be withdrawn from an RDSP before the age of 60?
Well, technically it could. Of course, you have the 10-year vesting, so it has to sit there for 10 years after the last contribution. And I have to get an answer to something because you think you know certain things and then you realize maybe you don't. The 10-year vesting period starts to click from after the last contribution, but does the $1,000 bond, is that a contribution? Because of course it contributes automatically.
Right.
I've always presumed that it was from 10 years after the parental contributions. So we have clients, for example, whose children we expect will have a shortened lifespan. So what you do is instead of contributing for 20 years, you contribute for 10. Or maybe you've just started them and 10 years have already gone by since they were set up. So what you do is you make your retroactive contributions over a 4-year period.
Mm-hmm.
You pick up 10 plus 4, and then you stop. And then you wait 10. and then the grants and bonds are vested.
Okay.
So yes, there are circumstances where if the lifespan is less, or you simply stop contributing, then it is possible that you can withdraw sooner.
Okay, Greg has a question here.
Greg's questions are always good questions.
If the person on ODS, or what is he talking about? RDSP, someone with an RDSP, if they do not require the money and it is not touched for 10 years after the 90,000 has been allocated to him, will the 90,000 in grants and bonds be fully his? Also, if he dies and his sister is the beneficiary, are the tax implications severe for her to inherit those grants and bonds?
Well, firstly, tax implications, no. Now, of course, it's anticipated that tax-wise, the child will receive the money. And of course, the child has tax credits of $20,000. So, you know, the formula that pays money out there will be an income component. It's not going to be 20 grand. So the beneficiary isn't going to pay tax. As far as the sister, she's not going to get regular payments with a component that's income. She's only going to receive this money if her brother is deceased. And of course, the RDSP is not designatable, but he could leave it to her in his will. And what happens is he dies, and the RDSP falls into his estate. And so there could be tax implications for his estate. But you know, it's just not the same for the sister.
Yeah.
You know, she would simply receive the inheritance. His estate would pay taxes. How that would shake out, that's a very good question. We'll have to run some of these scenarios because, of course, I've had clients whose children have passed on, but at this point, most of these children, the grants and bonds are not vested, right? They all go back to the government. And all you're talking about is the parental contributions of $15,000 to $30,000.
Okay.
Well, so what was his first question? First point?
If he does not require the money and it's not touched for 10 years after the 90K has been allocated to him, will the full 90K in grants and bonds be fully his?
Yeah, it's all his.
Yeah.
But what happens is when he turns 60, the formula starts to give him monthly payments.
Right. Oh God, there's a lot of questions coming in here.
Hi, Sharon.
I am the sibling of a 48-year-old disabled woman and the mother of a disabled 16-year-old. I don't have guardianship for either. When is it advisable to have this set up, and when can't it be? She's also adding her sister has POAs, but these have limited power and her son is too disabled for them.
Well, if your sister can sign powers of attorney, and if whoever you're dealing with will hang their hat on a notarial copy of that power of attorney, then just go with that. But if you find that that there's some significant issues and you're just not getting cooperation and it's just not working, then you might have to apply for guardianship for your sister.
Mm-hmm.
And as far as your son is concerned, if it's pretty clear that he's not competent, then it could be well appropriate that you apply for guardianship for him. Now, you'd wait until he's 18 to start with, because if you apply for guardianship, there's a procedure when he's a minor, and then when he turns 18, that's all gone, and you have to apply again. So, you would wait till he's 18. We have a situation right now where the parents are waiting. They're going to wait 4 years because the child with disabilities is 18, but there's a son who's going to be a guardian with the parents, and he's 14. So we're going to wait 4 more years, and then we're going to apply because the other son who's going to be a guardian is too young to be a guardian right now. So we've got them on a list, but we won't apply for 4 more years.
If the RDSP account holder is a parent and the disabled adult is the beneficiary, no contributions have been made since she reached 49, does she automatically start receiving payments at age 60, or does an application have to be made?
Well, she'll start receiving payments automatically.
Yeah.
And that's the awkward part, because she'll get the check. Parents may not be ready for this. We've got a situation right now where a brother has turned 60. He lives with his sister. Sister pays all the household bills. And now he's received this money, and he's quite capable of depositing it into his account and spending it. But he refuses to help with household bills. So.
Yeah. If a parent dies without a will, can the disabled person receive $40,000 or less from the estate to them in a lump sum payout? I'm guessing this is in regards to the ODSP exemption.
Parent dies without a will. Can the disabled person receive $40,000 or less from the estate? Well, sure.
Huh?
Yeah, I mean, they can receive $40,000 within their own asset test, and then there's a further $100,000 exemption flowing from a death as well.
Right.
This is a big part of our estate work. All the people who weren't my clients when they died, I'm then contacted by their children or by a lawyer or someone, the executor, who then says, well, my dad died. I have a brother with disabilities. He's going to receive money. What do we do? So you can see that there's a far larger number of people who are going to die, not my clients, with no Henson trust, where there will be an inheritance for somebody and no Henson trust. And then I'm going to be contacted. This happens every day. So it's the bigger part of my estate work. This is on the ODSP side. This is the bigger part of the estate work.
A question about survivor's pension. For the OMER survivor's pension, does it happen automatically, or would the disabled child need to apply for it?
No, you have to apply. And of course, if the child's not competent to apply, he can't apply.
Right.
So somebody who's his legal representative has to apply. And fascinating thing is that if you don't apply, like for example, client family in Windsor some years ago now, a son, special needs, dad died, OMER's employee, 4 sisters. And one of the sisters, who was the main mover, it came to her attention that dad had died and that there was potentially this pension for her brother. So let's see if I can get my numbers right. He had died 5 years before, and the pension for the brother was about, at that time, was about, I think, $800 a month. But the point of the story is that when you do apply, if you should have received the pension, you get the retroactive amount. Right, it's not lost. You get the retroactive amount. So what happened was he got about I think $60,000, and it was brought to ODSP's attention, and ODSP said, "Oh, well, that's our money," and they were right, because the amount that he received from ODSP was slightly more than ODSP. I forget the exact numbers. This was in 2001, but the numbers were slightly greater than ODSP. So what happened was he was disqualified, and retroactively he owed the money that he received to ODSP. So now, you know, he's on OMERS. He gets $10 more a month than ODSP, and no drug coverage. So.
I bought a condo for my son to reside in, and it is in my name. Does it have to stay in my name and then go into the Henson Trust for him to have after my death? Can it not go into his name at this point?
Well, it could be put in his name, but we'd have to discuss that. Is that appropriate? You could. I think over all these years, I've only had 2 families who actually put it into the name of the child. If he married, it would be divisible. If he divorced, he could sell it and take the proceeds. You know, these are the issues, obviously. But if it would otherwise be appropriate, then you certainly could stick it into his name. Otherwise, you can keep it in your name. You die, it's subject to probate. There's a deemed disposition. There's capital gains tax. It could then go to the trust in your will for him. It would thereafter be a principal residence because he's occupying it. If he qualifies for the disability tax credit, we should talk. How many people have we got?
102.
Oh, that's pretty good. It's 12:02. Do people want me to continue for a bit, or?
Well, maybe take a few more questions before we wrap up. If a trustee of a Henson Trust or other trust dies, who takes over?
The trustee dies. Well, the trust provisions in your will should have alternate trustees. A lot of times I find in reviewing wills that do have trusts, I find that the executors and trustees are also by default the trustees of the trust for the child, which could well be exactly what you want. But the way we structure it, we have a separate trust set up where it's clear that the trustees are otherwise specifically named, because what happens is, if what you're doing is the executors for your will, you're often not planning for somebody as young as your child. You know you need somebody like your brother if your wife has predeceased. And maybe it is one of your kids as the alternate, that could well be. But have you fully planned for the succession of trustees? Well, probably not, because you're not thinking that far as executors of your estate. You're just thinking of settling the estate and you're dead, right? And you've planned for that type of time period. But with the trust provisions, you have to have as many alternates as you can. Sometimes you have lots, other times you don't have lots. And what we do, and I've only seen this in 1 or 2 of the wills that I've reviewed, if you don't have a clause in the trust arrangement that allows the last, like for example, the last surviving trustee to replace themselves, to pick a replacement, then you have to go to court. It's a variation of trust application, because you know that you need a new trustee and you know who they're going to be, but somebody has to get a lawyer and apply to the court. And there's 2 ways to do it. One is by a brand new probate application in the old court, and you have to serve everybody, even though they were served decades ago, to replace the executors, or you have a trustee variation to replace the trustees in the trust. That's more complicated, actually. But if you have a clause in there to allow the last remaining trustee to replace themselves, that's all you got to do, right? It's not rocket science. But I've only seen that in other wills that I've reviewed with trusts twice, and yet it makes a lot of sense to me.
There's an interesting one here. If income is used to acquire medical items or services related to the injury or medical condition, would it, regardless of amount, be considered exempt income for ODSP purposes?
I would think so, yeah.
Yeah.
It's a disability-related expense.
Okay.
Yeah.
Sharon again, in regards to guardianship setup, is it advisable to have this done before the child is 18?
No.
No. Okay, that was her question.
How many questions did we get?
We've answered 93. There's still 30 open.
Wow, we got answered 93 questions.
Mm-hmm.
And you did you did what? How many polls did you do?
4. So I did the wills one.
What's it say?
43% of people have a will that's up to date.
Half, yeah, okay.
36% have a will that needs to be updated. 16% don't have a will but would like one. And 5% are just looking for information.
Okay.
Pretty standard.
That's about average.
Yeah. And then the last one was how people heard about the webinar. 66% are subscribed to your emails. 18% found out through friends or colleagues. 12% clicked other. 1% Facebook, and 4% is another online source. That's interesting.
Yeah. I'd like a printout of that when you have a second.
Yeah, for sure. Chris is asking, can somebody on ODSP receive $30,000 inheritance, and will that fit under 40,000 assets he can possess?
Yeah, and you have a choice. You can either receive the 30,000 and just keep it as your asset within the asset test, but you probably will be deemed to have received it in the month received and be overpaid ODSP for that month, and they would then claw back the 1151 at the rate of approximately $50 a month. If you set it aside in a separate account and explain that you've received it as an inheritance, then you may be able to avoid the income in the month received problem. I can't guarantee it. We find we succeed about half the time, you know. But if you have a separate identifiable account to have received this inherited amount, then you may well be able to avoid the income in the month received, and also not have it affect your 10,000 over 12 months.
Terry's question, are the rules for distribution of the residue assets in a Henson trust on the death of the disabled person statutory, or do the rules have to be written into the will or trust?
It's in the will, whatever you like. There's a distribution clause in the will. It's generally, you know, it goes in some logical way. It goes to the siblings, could go to charity, could go to the grandchildren. If appropriate, we have a few cases where the distribution clause is pursuant to the will of the beneficiary.
If more than two members are named in a Henson trust, 2 disabled family members, is the amount shared equally or at the discretion of the executors?
It's clearly at the discretion of the trustee. Okay. Now, you can do informal things, such as leave a letter of wishes to ask the trustee to try to treat it equally. And the trustee could invest it in separate pots of money.
Okay.
you know, and they could say, well, here's your pot and here's your pot, and you know, they could do that, but it is up to the trustee.
Right. Some of these are just a little too complicated. If RDSP is collapsed due to loss of DTC, does the child get to keep bonds and grants that are older than 10 years?
No, it's not a rolling thing. If they're vested, they're vested. If they're not, they're not.
If the person with the power of attorney for the RDSP dies, can the beneficiary give power of attorney to a non-relative to keep the RDSP alive?
Oh, yeah. Yeah, they can appoint anybody as their attorney.
Okay. Does guardianship involve a declaration of incompetency? Something that many...
Oh, yeah.
Okay.
Yeah, you have to have two capacity assessments to determine that the person is not capable as to person and as to property.
Okay.
Or perhaps one or the other, but generally it's both. And you have to have a capacity assessor make the assessments, and there's a standardized procedure and certain standardized questions, and they each cost about $1,000.
48-year-old single disabled son who has become disabled in the last 5 years, cannot function in the workplace. Will the fact that he's living on his own and has a mortgage prevent him from qualifying for a disability pension? He has no savings.
No, he could apply for ODSP. And it would be better than CPP if somebody said, well, you know, you used to work.
Doesn't owning a house put you over the asset test?
No, you can own a house.
Oh.
No problem. Now, you know, you know, you can read between the lines here that the parents are helping support him.
Right.
Right, because he can't support a house.
Okay.
Right. And ODSP won't be enough to support him, but it'll be 1151 better than he had, right? Just take a couple more and we'll say goodbye.
Okay. That one's already answered. Is everyone on ODSP eligible for establishing a Henson trust?
Yep.
That was already answered. If ODSP recipient has 40K in his TFSA, does he have to report income on any interest procured and withdrawn at that month?
Yeah, if you withdraw money, it's part of the 10,000 over 12 months, and you have to keep it below 40,000.
Okay.
It's not income, because of course the nature of a TFSA is that it's not income, but it's income for ODSP purposes.
Right.
It's not really income, but it's income for ODSP purposes.
Another easy one. Can a QDT pay out to a Henson trust? Can a qualified disability trust pay out to a Henson trust? Or is that not as simple as it sounds?
That doesn't make sense.
Okay, sorry.
Elena Popa.
When an adult with disability starts drawing from an RDSP, does this affect his ODSP income?
No, it's all exempt.
Oh.
And it doesn't affect OAS or GIS either once he's 65.
Amazing. Okay, maybe we'll wrap up.
Yeah.
Okay.
Well, thank you very much. I see we've got 95 people.
89 are left.
89? Well, that's pretty good. We had, how many did we top on?
120.
Okay, so most people have stayed,
yeah.
Which is generally what happens. People wait. They often want to talk to me separately, which is understandable. Mm-hmm. If anybody, could you just go to that, second screen? The one with the link to the family evaluation.
Oh, yeah.
I think it's the second screen. If anybody wants a specific assessment, which would be the equivalent of waiting and lining up to talk to me, then just fill in the family evaluation form and we'll get back to you. And I'd appreciate some feedback actually on the ebook. We created that 4 months ago.
About that.
Yeah. I'd appreciate it if some people would give me some feedback on the ebook as to whether they think that it has questions that aren't answered or that aren't clear. We've had a lot of downloads. I don't know how many hundred, but quite a few. And I haven't had any feedback, so presumably it's pretty good.
Okay.
But I'd appreciate any feedback if people wanted to take a moment to let me know what they think about it. That being said, I think that's the works. Thanks for taking part. What I'm going to do, this session was mainly geared at the 6,600 people who are on my newsletter list, and especially my clients, as a kind of a continuing education update, what's new. But what I'm going to do is I'm going to do webcasts, and I'm going to target or focus on each sector of the province, just as I did when I did on-site seminars over from 96 until about 4 years ago. So if you belong to an organization that would like to have a webcast specifically for your group, let me know. And what we'll do is we'll structure it for groups, maybe related groups. Like if your group happens to be autism related, maybe we'll work with Autism Ontario and try to cover, that spectrum. But I'm going to spend this year covering the province with webcasts, and if you would like it done with any group you're with, let me know. Thank you very much.